A very big decision from the Supreme Court overturning Chevron NRDC.
Carl, that's right. This is a sweeping decision by the Supreme Court to overturn what's called the Chevron precedent here. The reason it's significant is because it has enormous implications for the administrative state in the United States of America and all federal agencies and their ability to interpret the law. What the Chevron precedent was a 1984 case from the Supreme Court which held that in absence of other information, courts should give deference to administrative agencies' interpretation of the law. That gave a huge area of wiggle room for federal agencies to interpret what Congress meant when it passed given laws, if there was any gray area in those laws. What the Supreme Court is now saying this morning in a 6-3 decision is that courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. Chevron, they say, is overruled. Again, that is a 6-3 decision.
So why does this matter to us in the gun community? Well, let me break it down for you. It matters because it puts a check on the ATF and other agencies that have been pushing their own agendas for years. The ATF does not have the power to make laws. Only Congress has the power to make laws. And the courts are there as the people who are supposed to interpret those laws when they are made, not made up agencies that have a fetish for shooting dogs and helping gun smugglers smuggle guns. But the ATF likes to use the gray areas of law to make quasi-laws under the guise of rules. And the Supreme Court just pulled the plug on that nonsense. Remember the bump stock ban or the whole pistol brace fiasco? Both of those were a product of the Chevron deference. Now they technically can't do that anymore. The ATF love to just make up rules and dare the gun community to take it to court. Not anymore, at least technically. But I wouldn't be surprised if they try it again anyway. Chief Justice Roberts, in his opinion for the court, said it loud and clear. Agencies have no special competence in resolving statutory ambiguities. Courts do. Translation, federal agencies can't just make up rules as they go along anymore. It's up to the courts to interpret the law. Now, I don't know if I made this clear already, but this is a big damn deal. Legal experts like Eric Rubin from Southern Methodist University have pointed out that this ruling could have significant ramifications for the Bureau of Alcohol, Tobacco, and Firearms and Explosives, or the ATF. The ATF has been in charge of regulating firearms and has issued rules in response to advancements in firearm technology like bump stocks, ghost gun kits, and pistol braces. But now it's up to the courts, not the ATF, to interpret these federal statutes, as it should be and how it should have always been. It is not their job to make laws under these types of statutes. He continues by saying that this 6-3 ruling gives the courts unprecedented veto power over federal regulation, which could also dilute the authority of other agencies like the FDA, EPA, and the Consumer Product Safety Commission. It's a bold move and it's going to shake things up across the board. It's only going to shake things up across the board because it shouldn't have been like this to begin with. They don't like the idea of this because right now the courts lean conservative, i.e. towards the Constitution. Whereas generally speaking, when we start talking about judges that lean further to the left, they use the bench and the position as a way to advocate their own policies. And that's not the way it's supposed to be. But here's the kicker. Congress can pass legislation directly addressing these areas of law, and the court has suggested as much. However, with political polarization and slow-moving Congress, it's anyone's guess how quickly or if they'll act on any of these issues. So, what does this mean for the Second Amendment and gun rights going forward? Well, it means that the power to interpret and enforce laws is back where it belongs, with the courts. This ruling is a check on the executive branch's power, ensuring that our rights can't be stripped away by unelected bureaucrats pushing their own agendas. This is a victory for every gun owner in America and a step forward in protecting our constitutional rights. Now, if you're like me, you believe in keeping America tactical. That's why I'm excited to share my line of state-specific Keep America Tactical shirts, drinkware, and hats. Whether you're repping Texas, California, New York, or any other state, I got you covered. These shirts and hats aren't just about showing pride in where you're from. They're about standing up for our Second Amendment rights and showing the world that we are proud, responsible gun owners. So head over to shop.mrcolonnoir.com and click the link in the description section and grab your own state-specific Keep America Tactical gear. And let's keep America tactical, one state at a time. So what are you waiting for? Click the link in the description section and get your gear and join the movement. Keep America tactical. One thing's for certain and two things are for sure. Politicians and tech giants don't want gun content to be recommended to you. And we're all fighting this culture war together. Now, you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together, we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.